And with some people, Lord, we have to sit for some time and stand for some time, and I was standing table.
Even for conferences, that desk now helps a lot, my lord. Stand and do conferences.
Yes.
That's very helpful.
So you do that, is it?
I do that. I've started doing it. So it helps not sitting through the conferences myself.
It's better that people, lawyers start doing this from an early age, rather than wait for us like to reach our age, and then it become difficult to resolve. So there are two aspects.
Yes.
As I said, the segregation aspect, whether the candidates who have been found to be tainted, or rather the tainted and untainted, can they be separated? Is there enough material on record to segregate them? And whether the defects found are so widespread that the whole must go, the whole selection process. That is one part. The second part, not with which the state is concerned, because under the Act and the rules, there is a central commission which makes the selection, and there are boards, regional boards, which the board of secondary school, the board of higher secondary school, the board of madrasas, so who make appointments. The state's statutory duty is limited to creation and sanction of posts and bearing the burden of salaries. So they do not come directly into the process of selection or appointments. Now, that is not to say that the states overall are not responsible for the education in the state, but the various selection processes which are held from time to time are in the domain of the Central Commission and the boards. So I'm confining my submission on behalf of the state to clause 8, which your lordships had stayed for the time period. I'm not concerned with the segregation part. The commission's council and the other learned councils who are representing the candidates who are affected, they will be assisting your lordships on the question whether segregation is possible or not. They have the material to show. I'm only confining to clause 8 direction which has been issued and stayed by lordships.
Yes.
Incidentally, my lords, on 23rd of November 2022, Justice Gangopadhyay had for the first time by an interim order, interlocutory order, directed a CBI inquiry into the question of creation of supernumerary posts. That order is at page 506, at page 515, and in an SLP filed by the state, my lord, the Chief Justice was pleased to grant an interim order stating that, which is still pending, that is on 25th of November 2022, which is at page 518.
Yes.
That matter is still before the lordships. And one of the reasons, Lord, for this intervention by this court was that none of the writ petitions involved any challenge to the order of the state government creating supernumerary posts. That was never in challenge. The lordship turns to page 518 of volume 2.
Yes.
And the matter came up before Justice Gangopadhyay on account of the fact that the Selection Commission had moved a IA, which they call CAN 2 of 2022 in this matter, where they sought permission from the court for creation of this supernumerary post. But it appears that inadvertently or whatever it be the motives, I do not want to go into that, but they mentioned to accommodate illegal appointments. The idea was that when the appointments are set aside by the court on account of these corruptions, etc., and there's long drawn litigation which is going on in that court and this court. So in the meantime, some supernumerary posts may be created so that those who are in the wait list, they could, regarding whom there is no issue as yet, so they could be accommodated. For example, Milord, in one case, this lady Soma, Milord, she had approached the High Court and the High Court itself directed. Her case was that some people who are lower down and not in the list have been appointed.
That is a medical case. I think
Medical case, so therefore that was appointed. Now, if you kindly see page 519, item 6.
Yes.
Lordships have extracted the order of the learned single judge in the High Court. It is thus submitted that if any other illegality concerning the appointment of Group D staff is identified, it is humbly proposed that apart from giving recommendations and appointment to genuine candidates as observed by this Honorable Court by its order dated so-and-so, supernumerary posts be also created to accommodate those whose appointments are subsequently found to be invalid. Such proposal will result in no loss of jobs and enable such appointees to have means of livelihood. However, in the event of such proposal being accepted, appropriate directions be given that such persons do not have seniority over those eligible for appointment. So while this order direction was being passed, the state in fact appeared and told the court that this is contrary to the state's order creating the post, because that was meant for waiting list, not for invalid appointments. That those who are declared illegal, they will again come back through supernumerary posts. That was not the intent, and we produced that order. But even after production, nobody challenged that order. Even that's what I'm showing his purpose is. Nobody even then amended the petition to challenge that order at all. And the Lordships have then wrote at page 509, paragraph 4, state this. In paragraph 9, page 520.
Yes.
So this petition is pending. So the question is identical whether the... Yes. So neither it was an issue, nor it was made an issue after production of the order, and it remained as such because my lords had stayed it. Now, the other thing is that with respect to these 6,861 posts which were created,
6,861.
Kindly turn to page 367 of volume 1. The proposals had come from the commission and the board to the state government saying that they have themselves detected a lot of cases of rank jumping and all that.
Yes.
So they themselves detected. So since they had detected, they recommended that from the wait list, that was their recommendation, which was accepted. And kindly see at page 367, having recorded the proposals at the bottom of the page 367. Now, therefore, in exercise of power conferred under Section 19 of the West Bengal School Service Commission Act 1997, the governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staffs as detailed at para so-and-so for absorbing the wait-listed candidates in the supernumerary posts so created as per approval of the state cabinet. And please turn overleaf In exercise of the powers under Section 3(2) of the West Bengal Board of Secondary Education, Appointment, Confirmation, Conduct and Discipline of Teachers and Non-Teaching Staff Rules 2018, the Governor is further pleased to direct that appointment letters to such waitlisted candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extant rules, subject to the outcome of pending litigations before the High Court of Calcutta. So there was no attempt to overreach the court.
Can we just go back to that order for a second?
Yes.
That's the page, Annexure 7, right? Page 367.
Yes.
Right. I was just trying to locate it up now.
I'm so sorry. At the bottom of the page I was getting. So I think PDF is different also.
398.
398. I'm so sorry. At the bottom of the page is now therefore in exercise of powers conferred under Section 19 of the West Bengal Service Commission Act, the Governor has been pleased to create 6861 supernumerary posts of teachers and non-teaching staff as detailed at para 4 for absorbing the waitlisted candidates in the supernumerary posts so created as per approval of the State Cabinet.
Yes.
And the next page, Vinod, 399, that's PDF 399. In exercise of powers under Section 3(2) of the West Bengal Board of Secondary Education Rules 2018, Governor is further pleased to direct that appointment letters to such waitlisted candidates should be issued in terms of recommendation of the West Bengal School Service Commission in strict compliance of the extant rules subject to the outcome pending litigations before the Honorable High Court at Calcutta. So this was all subject to the High Court that if they are set aside, in that event they are to be accommodated. That was the spirit with which this order was issued, and keeping in mind the spirit, not barring Soma, nobody else was appointed at all. The posts remained vacant.
What was the occasion to accommodate 6,800 waitlisted candidates?
The objection really will be now this, that if at present there's no question of appointment because once the whole selection process has been found to be vicious.
But why did the government create, what is the need
That
for
was
the government
during
to
the
accommodate?
process. During the process when the selection list had, this judgment had not been delivered, in between the process, there were various inquiries being done, one by Justice Bag's committee, then by CBI, affidavits were filed. Commission itself was required to go into it, and they also filed affidavits showing how many rank jumpings, etc.
This selection related to which year?
The same selection was. It's 2016.
Right, and the government created posts in 2022.
They were creating because what happened in this case that all selection list was finalized in 2018. Then January 2019, all appointments had been done. Now this challenge itself was raised in the year 2021, that's after 2.5 years. So that's why in the process, because the records which are to be preserved for 1 year, they were weeded out. All this happened because after 2.5 years, therefore all this problem was arising. So of course, the problem was of our own making, so we are not saying.
Suppose a candidate on a select list or the waiting list were to file a writ under 226, give me an appointment. The simple answer would be to such a petition that, well, what is your vested right? After 6 years, you can't even get appointed.
Yes.
Because the tenure of a wait list can never be that long.
Yes.
Now, this was 2016
No,
selection.
in fact, in 2019.
2022, the government creates 6,800 supernumerary reports.
So, in fact, 2019, it was already declared that this panel is dead. Now, because the writs are being filed in 2021, 2022.
May I only add one thing? Because the reports came that there are potential irregularities and the matter was pending in the High Court, the fear was that tomorrow if they are struck down, there'll be a huge vacuum. It was in that background that a suggestion was made and a whole cabinet note after discussion was prepared that in case that were to happen, where would we go without 25 or whatever 10,000 who are struck down? So why not in the meantime take the waitlisted candidates against whom there is no allegation at all on a supernumerary post subject to outcome of the writ petitions which are pending. This was the suggestion.
Sure, sir.
Petition with this order has been challenged separately. Petition. So now the order passed by the state government, which is at page 367. This, as I said, this was never implemented, and ultimately, Lord, in November, a different writ petition, which is WPA number 25056 of 22, Meenakshi Ghosh, on 18th of November 22, WPA number 25056 of 22. That was filed directly challenging the order of the state government creating these posts, and the High Court was pleased to stay that order. That petition is still pending in the High Court. So the purport of my respectful submission is this, Lord, that it is one thing to say that these orders are illegal. Maybe because panel has expired long back, or the power doesn't exist, or that it was unnecessary. So therefore, the order is illegal and deserves to be set aside. And this part of the legality part is engaging the attention of the High Court in the writ petition which I just now pointed out.
250 of 2022.
Yes. 250, 56, 25056. So the legality of that, and we are today, given this nature of the order, the question of legality doesn't really arise. It goes, if the selection goes entirely, that goes also. The wait list also goes, everything goes.
But that, Mr. Dwivedi, actually goes against you, because if the entire if the selection itself was under a challenge, then where was the occasion for the government to use the wait list in that same selection process then for creating supernumerary posts? It's aware of the fact that the selection is challenged.
It's
that's
like
under
this.
a cloud.
Why
would you create supernumerary posts?
Now, can you look at it this papers? It was not expected at that stage that the entire selection will go. The way the proceedings were going, in between, there were some orders passed that 329 posts are appointees, they were invalidated. Then 800 were invalidated. So it was expected that some part of the tainted candidates will go, and therefore, there will be need to appoint from the wait list. That was according to the CBI affidavit, also 8,000.
Of how many candidates?
About 24,000 something. All I am trying to endeavor is to show that there is no malice behind, my lords. Malice in fact. Our expectations, on hindsight, one may say, or one hindsight also say that one should have awaited, my lord, the final judgment of the division bench and then proceeded to do something. What I am today questioning is the direction for a CBI inquiry. I am not on the legality part.
That's the point, basically.
Basically, I'm saying that CBI inquiry can be directed only if even prima facie the High Court finds that there is some criminality. So we may have gone completely wrong. It may be illegal. But the fact that we did not appoint, and the order said that it is subject to the orders of the High Court, and even the application of the commission said, my lord, we are seeking approval of the High Court. High Court could have rejected that application, the matter would have ended. Assuming the High Court feels that the two are interconnected. Though we said that commission's application is contrary to our order, but yet, for the sake of contention, if I assume that the High Court said it is Binami application, is somebody behalf of the government which is wanting to create, but we went to the court, the commission went to the court with an application permit. So court did not permit, the matter ended. It's not that we were trying to overreach and bring into the stream, my lord, some people from the wait list.
On your application before the High Court
rejected, never passed any order. It's stated, my lord, that they started investigating, and that order has been stayed by your lordships. Justice Gangopadhyay's order, he said that it seems that this is not from the chairman of the commission, there is some higher persons. So, I mean, I don't want to go into that.
So you sought the approval of the High Court. High Court didn't grant that approval, and therefore no appointments were made at all.
That was an application by the Selection Commission.
Selection Commission.
Which traveled to the Supreme Court, and your lordships passed the stay order. Ours was an independent exercise as far as supernumerary posts are concerned, because these are from the wait list and category.
Okay.
But I'm going a step ahead and saying, Lord, even if the
is there a finding of criminality by the High Court while referring?
Nothing. Can you see that? There's There's no discussion at all.
All right, that's the point.
That's my humble submission, and I rely upon this judgment of full Constitution Bench judgment of this court 2010 volume 3 SSC.
Yes. Page?
Page 571.
Name.
State of West Bengal versus Committee for Protection of
Yes,
Democratic
class.
Rights.
Well settled.
Para 70 and 71. The last two paragraphs. I'll just read out. Lordship may not.
That you shouldn't pass it as a no.
And that this para 71, Your Lordships approved minor irrigation case 2002-5 SCC 521. This court had said that an order directing an inquiry by CBI should be passed only when the High Court, after considering the material on record, comes to a conclusion that such material does not disclose a prima facie case calling for an investigation by CBI or any other similar agency. We respectfully concur with these observations. And in this case, Lord, with respect, Lord, there is absolutely no finding, Lord, the prima facie of any criminality, nor can there be. First of all, Lord, there is no issue. Even when we produce the order in the Can 2 of Commission, still thereafter nobody amended the petition. Nobody is saying, Lord, that this order has been passed with a malice. Secondly, in both the cases, our order also says, Lord, subject to the orders of court and the application itself of the Commission, though little misconceived and erroneous, still it said ask for permission. So there was no case, that somebody is trying to bypass the whole judicial process, and investigations going on and appoint from the wait list. And thirdly, nobody in fact was appointed. So in fact, there could not have been any finding of criminality, nor there is.
Mr. Dwivedi, the CBI investigation had been directed to continue by our court itself.
That's right.
So there was a CBI investigation going on in regard to the criminality in the main
In the main matter about those appointed.
Which would also include the waitlisted candidates.
Yes.
Now, if that was so, then is the High Court not really only in this direction of the High Court, is it not in furtherance of what we have directed ourselves?
No, your lordship directed in continuance of CBI inquiry, which was already going on with respect to those who have been appointed, namely rank jumping, namely outside the sanction post, more than the sanction post, they were being appointed. Those who were where about this OMR sheets was problem. So they were investigating the selection process.
But same selection process, right?
But we have nothing has been appointed. Nothing has happened. Where is the question of criminality if the government passes an order which remains on paper? So what can be an attempt to commit what crime, my lords?
All right, we'll
So
look
that's
at it.
the issue, my lord, which I am raising. And moreover, my lord, lordships have said apart from this judgment that there has to be compliance with natural justice. No pleading, no issues. Where is the hearing going on this aspect? Focusing on this aspect. Then the state should have been put this issue directly, not whether why should not that CBI inquiry be directed? Then all these arguments, Lord, we would have placed before the High Court, where High Court would have considered these questions, these aspects.
Thank you, Mr. Lewis.
May I just add two submissions for your lordship's kind
Yes.
consideration? My lords, admittedly, it is a fact that a single judge of the Honorable High Court was seized of the cabinet note issue. This matter was neither argued, nor were we ever called upon before the DP, nor was the subject matter of the matter pending before the division bench, the cabinet note at all. But more importantly, please see, where does the impugned order go completely wrong? Kindly have page para 265 on page 226 of the impugned order.
Ara?
265.